Hello, everyone. Today I want to discuss one of the most important recent developments in European law regarding statelessness. From June 2026 onward, EU member states will have a legal obligation to identify and record indicators of statelessness during asylum screening and migration procedures. Legally, this is a very important step. For many years, statelessness existed inside a kind of legal blind spot. Authorities often focused only on migration status, asylum status, or return procedures, while the issue of statelessness itself remained secondary. Now, at least formally, Europe is beginning to recognize that statelessness is not a marginal problem. But while reading the newest EUAA and ENS reports, I also had another feeling. And honestly, that feeling scares me. Not because Europe is doing nothing, but because the institutional culture of legal development in Europe moves far too slowly compared to the human reality of the problem. And statelessness is not a theoretical issue. For the people affected, statelessness influences every aspect of life: identity, travel, education, healthcare, employment, housing, family rights, and sometimes even the ability to exist legally before the state. A child born inside the European Union can still spend years without clarity regarding nationality, and this exposes something important about modern legal systems. Most European migration and nationality systems were built around one assumption: every person belongs somewhere. Because of this, the law focuses heavily on identity verification, documentation, preventing fraud, and ensuring that people can eventually be returned to another country if necessary. From the perspective of the state, this logic is understandable. States must protect the integrity of legal identity systems, but reality is often more complicated than legal theory. Not all stateless people arrive from outside Europe. Some are born inside Europe. Some are born into legal contradictions between multiple states. Some inherit administrative failures that no authority fully knows how to solve. And once such situations appear, the entire system begins to slow down. The recent European reports confirm something very important. Even now, in 2026, most European countries still do not have a real formal statelessness determination procedure. This creates a dangerous paradox. Authorities may soon have a duty to identify statelessness, without having a practical mechanism to resolve it afterward. And this may create a new category of people: identified, documented, but still unresolved. This is where the problem becomes truly dangerous. Because administrative systems are designed to process ordinary cases, exceptional cases disrupt administrative logic. When reality no longer fits inside predefined legal categories, institutions often react slowly. Files move between authorities. Responsibility becomes fragmented. Every institution acts partially correctly within its own competence. And meanwhile, years pass. For adults, this creates instability. For children, it shapes identity itself. And this is the point where I believe Europe still underestimates the seriousness of the problem. Europe has many laws, many conventions, many studies, many human rights instruments, many policy papers. But the real problem is not the absence of law. The real problem is the speed of institutional adaptation. European legal systems evolve slowly because they are built on caution and procedural balance. Normally, that is a strength. But in statelessness cases, slowness itself becomes harmful. Because time is not neutral. A child does not experience statelessness as a legal debate. A child experiences it as uncertainty, as delay, as exclusion, as confusion about identity and belonging. And while institutions continue discussing feasibility studies, implementation frameworks, and future reforms, real families continue living inside unresolved realities. This is also why I increasingly believe that modern legal systems will eventually require mechanisms capable of dealing with exceptional cases more directly. Not because the law is weak, but because reality is more complex than legislation can fully predict. No legal system can eliminate exceptional cases completely, and statelessness demonstrates this better than almost any other field of law. Modern legal systems rely on categories: citizen, foreigner, resident, refugee, documented person, undocumented person. But some people exist between categories. And once someone falls between categories, the system often becomes uncertain about how to react. That is where structural gaps emerge, and that is where legal systems risk becoming disconnected from human reality. The central question Europe still avoids is no longer whether statelessness exists. Europe now recognizes that it does. The real question is different. What happens when a person cannot realistically be assigned to another state and has already lived inside Europe for years, especially when that person is a child, especially when multiple legal systems are involved, especially when procedural solutions technically exist but practically never arrive? This is where the next major legal debates in Europe will emerge, not only around migration, but around responsibility. Who becomes responsible when every institution partially recognizes the problem, but none fully resolve it? Europe is finally beginning to recognize statelessness, but recognition alone is not enough, because for many families the problem was never invisibility. The problem was always the absence of a system capable of resolving exceptional realities before years of life disappear inside administrative uncertainty. Thank you for watching. If you are interested in statelessness, comparative law, European legal systems, and structural legal gaps, you can follow my work at law-clinic.du and Staatsangehörigkeit-klärung.de. Please subscribe to the channel if you want to follow future discussions on European law, statelessness, and exceptional legal cases.